Hello, everybody. So delighted that so many of you are joining us for this, I don't know, 20th, 25th, 26th book club. I've got to check what number we're up to, but we've been doing this for several years now. As many of you who have joined are aware, this was once upon a time an in-person book club amongst a bunch of us privacy geeks in the Washington, D.C. area. And we went virtual long before COVID because we had lots of folks who wanted to join and read along and discuss, and when lucky, actually even have a chance to meet the author. So I'm really, really excited that many of you purchased, read, We the Robots, Regulating AI and the Limits of the Law by our guest celebrity author who is here with us tonight, Simon Chesterman. Simon is the Vice Provost, Dean, and Professor of Law at the National University of Singapore, Senior Director of AI Governance at AI Singapore, and someone who many of us have long looked to for thoughtful thinking around a range of data and tech policy. Super delighted that he's with us tonight. As soon as I introduce the other folks around our table here, Professor Chesterman is going to give us a little bit of a take and explain what his goals were with this book. This is not a giant academic tome, so I'm always interested when I talk to an academic who traditionally gets respect and credit and appreciation for writing academic tomes. But this is also not an airport book where you're going to, get your 10 top tips of, how to fix AI or how to code or the like. It's perfect for our audience. It's this sort of in between thoughtful and deep enough and footnoted and cited and based on, a huge review of literature and legal and history. It's really aimed in many ways, I think, at regulators or those of us who are trying to think not simply just about what's good about AI, what's bad, what's changing, what are the problems. We get some of that, but we get a thoughtful look at how regulators might look at adjacent areas of regulation, phenomenal examples from history, from other legal disciplines. So many of these conversations about tech policy are so EU and US driven ping pong. To actually see someone do a real global scope, looking at China, looking at Australia, looking at the US, looking at Europe, looking at jurisdictions around the world, and taking some of the takeaways for how those jurisdictions have handled and been thoughtful. Anyway, I don't want to get carried away, but what an exciting...
Please do. You're doing a great job.
What an exciting read this is. So joining me for the discussion, and it will be a discussion, and I'm watching the comments and the people participating. So we will try to include you. I'm seeing folks from Gabriela Zanfa Fortuna, our pal our peer from Detroit. We've got folks from NIST. We've got folks from Brazil, and lots of folks who I recognize as actually being involved in many of these regulatory conversations. But I have some VIPs in the audience for when I run out of words, which isn't going to happen, but I will shut up because there's some phenomenal people here who I know you all want to hear from. Let me first introduce the insiders, two of my future Privacy Forum colleagues, Clarisse Girot. Clarisse is usually in Singapore and leads our Asia Pacific team, our growing Asia Pacific team. She's actually waking up quite early in the morning in Paris because she's 2 a.m. Because it turns out she's not in Singapore today. So delighted to have Clarisse with us. And Dr. Sara Jordan, who is our AI and research lead at Future Privacy Forum, and academic who we lured out of the warm holes of academia to battle and discuss and debate in this think tank world. So Dr. Jordan, thank you for joining us. And Fumio Shimpo, Professor Shimpo, joining us from Keio University in Tokyo. professor, PhD in law at the Department of Policy Management. Fumio, Dr. Shimpo, welcome.
Nice to meet you. Thank you.
And last but not least, David Hardoon, who is the Chief Data and AI Officer at the UnionBank of the Philippines. However, he is in Singapore, not in the Philippines, at least at the moment. And he comes to us with a long background, not only in AI, a PhD in computer science, but a history in the financial sector and money laundering, and has been an advisor in industry, to government. And in his bio, he noted that he's less of a data science than a data artist. So we're going to have to find out exactly what he means by that. Without any further ado, Professor Chesterman, why this book? We've all been reading all the AI tomes and all the books that talk about how AI is going to save the world and is better than electricity and more important, or is going to be the biggest disaster for the climate and for robots. This is a real regulator book. I feel like I want every regulator who's thinking about drafting AI legislation and thinking about things like human in the loop to actually go through your analysis so they actually focus on what their goals are and how they can actually do this in a comprehensive way. Floor is yours.
Well, firstly, thanks, Jules. Thanks for organizing this, but also thanks for that really kind introduction, which is both generous, but also I think quite insightful, because you've really got the purpose of the book, which is trying to do two things. I'm not a computer scientist. I'm not an expert in the technology side of AI. But what I was trying to do with the book is precisely translate some of the questions that technologists are asking and link it with the potential answers that regulators should at least be thinking about. And so that's true both in terms of the purpose of the book. It really is focused on, okay, what should we be thinking about in terms of the regulation of AI, but also the audience. It's not meant to be a pure legal text. And I'm delighted, I think you're right, it's probably not going to be on the airport bookshelves, but I do hope it's accessible. And in terms of the actual sort of, that's, if you like, the pitching of the book, in terms of what I was trying to do, really it came out of more than a decade's work, really focused on data protection, which is how I got to know Clarisse in Singapore. And I thought Singapore, originally on data protection, now on regulation on AI, really did point to the need for a very pragmatic conversation about how we regulate in the digital age. And that, again, you're right, that the discourse is really dominated by Europe and the United States. Europe, if you like, with a real focus on rights, and I think that's been incredibly influential. We've seen that with the General Data Protection Regulation, the Data Protection Directive before that, the Brussels effect. And if you like, a kind of counter-narrative in the United States where there's no federal regulation of data and you've got real market dominance. And I thought Asia was clearly important. Singapore potentially had something to offer. And so one of the benefits of being the dean of a law school is I've access both to all of my different colleagues, those working on tort, criminal law, law and technology, but also at NUS we have this AI Singapore initiative. And so I got involved there, and that enabled me to talk to some of the technologists. My one regret in this process is that I'd originally planned an extensive visit to China to talk in person, but I was doing some of the research just as COVID was hitting, so much of that was virtual. But really the intention is to try and help clarify some of the questions around AI, because most of the literature on this, on the legal side, tends to gravitate towards two extremes. It gravitates either towards the regulation of specific technologies. So there's a lot of work on data protection, on autonomous vehicles, algorithmic bias, and so on, important literature. Or at the other extreme, it's the apocalyptic, how do we control the robots? Should robots have rights? The kind of robot consciousness space. And I wanted to really look in the middle, and the kind of the partially boring conclusion is that a lot of our existing legal rules can actually deal with many of the problems that AI poses. There is a need for some new initiatives, some new types of rules, some new application of old rules to new systems. But I think a lot of the hype around AI exaggerates the near-term problems because of an uncertainty about the medium and long-term implications of AI. So yeah, long way of saying it's a fascinating topic, and I hope I'm providing some useful clarification of the sort of issues that regulators should be focusing on.
in the world of privacy and data protection, some have suggested that we're turning it into the law of everything, because if data is involved, data protection seems to be setting the rules, and so our scope is ever expanding. But what we don't seem to be very good at is well understanding the disciplines that have grappled with some of the same issues. And I think one of the areas that was most insightful for me were the different sectors that you looked to and pulled out the depth of analysis that was there, whether it was tort law, some of the areas of military use of mercenaries and of soldiers and extended troops under command. I thought was quite fascinating. Very often we kind of start with well, don't use AI for death-defying purposes. That's crossing, and then we don't spend any time understanding that people have grappled with the ethics of how you use a big kind of command and control system that you don't fully control for generations. And incredible depth of insights from the world of mercenaries, tort law. What were the other? There were a number of other areas where I think you found really fruitful comparisons. What were some of the others outside of?
So I mean, one of the problems is precisely when you've got a new technology, there is a tendency to think this is the first time we're ever confronting anything like this. And I suppose one of the things I'm trying to offer is to point out that many of the questions posed by AI are not actually that new. We've long had the dilemma of how product liability should apply. So product liability maybe is another example to add to your list, that we've had dangerous technologies emerging over time. And the question, well, how do we get the benefits and mitigate the risks? And so I think liability rules are quite important in terms of properly allocating risk. And if you like, I mean, I hope one of the contributions of the book is to draw these comparisons, but also to break up the question of regulating AI. I think there should be no disagreement that we need some kind of regulatory structure to deal with the potential threats posed by AI, but it's not one question. And so I try to break it up into three types of questions which lead to different answers. And in some situations, really all we want to do is mitigate the risks. So with driverless vehicles, for example, we want them to be safe. We want losses to be allocated appropriately. If someone's killed or injured by an autonomous vehicle, it would be very strange if the risk was purely pushed onto pedestrians. Well, it's your risk getting onto the road. And so there are ways of dealing with that through product liability, through insurance, and so on. And that kind of optimization of outcomes is actually something AI is also quite good at. But that's only one area. Because in a second area, we're not just talking about optimization. And I think lethal autonomous weapons that you touch on is one of those areas. Some people will argue that we shouldn't be delegating life and death battlefield decisions to autonomous entities, to AI systems, because it's all too complicated. It's too hard for a machine to make these fine-grained, nuanced distinctions in the battlefield in the way that a human can. And I think that's a pretty terrible argument. Because all indications are that AI systems will get better and better at making those decisions. And actually, my background is public international law. I interned at the War Crimes Tribunal for Rwanda many, many years ago. Many war crimes, in fact, most war crimes happen because people are angry, tired, racist, sexist, and so on. These are all things that you can train AI systems not to do. So the reason we shouldn't outsource life and death decisions on the battlefield to machines isn't because they'll make worse decisions. They may well make better decisions. The reason we shouldn't outsource them, and here I'm aligning myself with the International Committee of the Red Cross, is because these should be moral quandaries. These should be hard decisions. A human should grapple with these moral decisions, and a human should be accountable for those decisions. And then a third area which touches on the mercenaries is that often when governments in particular are drawing on AI systems, immediately the connection to me was drawn with outsourcing. Because essentially what a government decision maker is doing, if he or she relies on an AI system, is outsourcing that decision. And so I drew the comparison with outsourcing to corporations. So if a government shouldn't be able to outsource decisions over, for example, sentencing policy to a for-profit corporation that makes decisions that they won't explain, then they similarly shouldn't be able to outsource it to a machine. And this actually has a kind of legal literature in the context of mercenaries, where most governments at least have some limits on the sort of things that they're willing to transfer to private corporations. So I hope with these different comparisons, it reassures people that although the problems we're grappling with in the context of regulating AI are complex, some of them are new, but many of them at least can draw interesting lessons from past experiences, and we can learn from past successes and mistakes in regulating new technologies and new areas of economic activity.
Simon, the only discipline I think you didn't manage to bring in from that I'll suggest in the 2.0 of the book is the Bible and the Talmud, which have these fascinating instances of the Romans came and grabbed the Christian or grabbed the Jew and said, you know, we'll kill you if you don't hand over those people, or we'll kill somebody. And there are all these variations of real historical situations where these sort of trolley type problems had to be, managed with moral and ethical guidance. You can redeem one prisoner or you can redeem two, but doing so will then create, this risk. So, but you certainly, I think, showed us not only lessons, but I say also a caution, because many of the regulators regulating in this area are also doing it without appreciation that there are regulatory regimes already in place when algorithms are used in those sectors. And so by creating sort of a layer that, maybe doesn't make any sense, that isn't coordinated, we end up perhaps sowing confusion, as opposed to, well, we want to preempt, fine, if you've thought of a better way, but please be aware that there's already a regulatory structure in place. Let me bring in Dr. Sara Jordan. And Sara, you read the computer science literature, the legal literature, the range of what's out there. What'd you learn from this book? What was your big takeaway? What did you like? What resonated with you?
Well, like all academics, I was really pleased to see that somebody else who wrote something that agrees with my position, which is that a lot of the things that we need to say about regulating AI have been said before. Like you said, like Jules said, from just war tradition to bioethics to consumer safety. Not much is new under the sun. AI may be new and novel recombination things, but doggone it, Plato was right. And a lot of things just aren't that new. The thing that I found really interesting was one of the twists that I think you gave in this book, which is using AI to regulate AI, right? Trying to help to use things like knowledge engineering or some of the more NLP driven things to extract from the regulatory infrastructure around the globe how it is we should regulate some of these risks. I thought that was, not only truly innovative, but an insight into an avenue for the use of AI that I hadn't thought a lot about. So if you don't mind, I'd like to ask you a question to spin out a little bit more on that, which is, given that we use AI in ways to, navigate like the labyrinthine tax code here in the United States, we use things like knowledge engineering. What do you see as the best AI tool for amalgamating the huge, massive regulation that not only exists already, but is going to exist tomorrow? I mean, think about the massive change that's going on with regulating AI in China right now. How can we possibly use AI to harmonize that and to make sense of it and to move forward in a productive and, well, less frictiony sort of way?
Yeah, I mean, this is a problem that predates AI, the kind of navigating the regulatory complexity of sophisticated jurisdictions. I mean, I think probably the easiest example, the US tax code, I think, is about this thick now. So even tax lawyers can't read the whole thing. And that's something AI is very good at, managing large amounts of data, processing large amounts of data. I suppose that the linking it with what Jules was saying earlier about kind of moral questions, the Talmud, the Bible, one of the things that I get very wary about is the suggestion that, well, if you just feed in enough data, the AI system can spit out not just the efficient answer, but the morally correct answer. And here, I mean, I just bring it down to first principles, that if humans have been grappling with these questions for thousands of years, the smartest minds trying to come up with the answers to moral questions, and we haven't worked it out over thousands of years. I don't think it's because our brains are incapable of doing it. I think it's because the questions are incapable of single answers. And so that's where, if you like, in the area of AI regulation, I'd split it into two questions. AI systems are very good at offering dispute settlement options. And so the example many people, including me, cite is eBay, for example. If you have a dispute on eBay, it's not really an AI system. There's an online dispute mechanism that very efficiently offers a settlement to both parties. So if you rely on dispute settlement, that's an easy way that AI systems can sort of navigate between two parties and come up with an agreed solution. Probably the best way in which AI can regulate itself is in preventing the either collection, use, or disclosure of data, or in the inefficient activities that AI might otherwise be programmed to do. So that's, if you like, a kind of self-regulation. What I'd be very wary of, and this is linked with the ethics question, is the idea, which is candidly, it's being explored in China, that you can outsource, again, that word, outsource to AI systems aspects of the judicial process itself. And I think, a bit like the ethics question, that kind of misunderstands the role of law, because AI systems, and there are people on the panel probably more expert in machine learning than me, a lot of this is essentially statistical modeling that is very good at drawing connections, drawing correlations, but that's not what law is. Law is not a backward-looking enterprise that merely says, okay, if this and this go together, then the third thing follows. Law is not like predicting the weather. If you did sort of rely on AI systems to take over the whole judicial system, for example, it might well be able to make decisions based on what had been done in the past, but that's not what law is. Law has to be forward-looking, and back to the moral questions, law has to grapple with these questions which have no clear answers, or at least have no answers that will be fixed for all time. So I think probably the biggest scope for AI systems and programmers in terms of regulation is first self-restraint, and then secondly, the management of large amounts of data to help us come up with efficient solutions. But that's very different from saying that they know what the right solutions are.
I'll note one area where we are rapidly building out sort of AI-driven systems that really do play a judicial role in many cases. The systems that determine whether you can continue to have a social media account and post and say very complicated, nuanced things. And we are mandating and regulating that the platforms, quick, fast, immediately, take down the bigoted, biased, fake, fraudulent stuff, which frankly, judges might debate, and certainly the political bodies are disputing, but we've outsourced it because we want the companies doing it quick, fast, and of course, accurately at scale. And here we seem to be driving forward without perhaps appreciating that humans and nuance and humor and the sophistication is probably a far way off. Dr. Shimpo, what's the perspective from where you sit? What's your reaction? What did you appreciate about the book?
Yeah. First of all, thank you for inviting me to this book club. Ordinarily, I'm reading many books, but I do not have any opportunity to talk directly with the author, and it is very precious opportunity for me. And also, I have read this book, and I found 7 issues that I should consider, and I'd like to discuss in the future in details about these issues. So, and one is sensitive and critical issues relating robot law, particularly, for example, lethal autonomous weapon system and such a very critical usage of AI. And second is regarding the concept of autonomy. So this means that we are now using the word autonomy, and when we think about personal autonomy, the meaning of autonomy as conceived by legal scholars is different from that. I think the autonomy as conceived by robotics engineering scholars, so who develop robots. For example, one of the examples is that the legal scholars' ideas of autonomy seems often to be used in a positive sense, in relation to the protection of individual human rights, and such as the dignity of individual. And on the other hand, on the contrary, the robotics engineering scholars' idea of autonomous tends to mean runaway of computer program. So in other words, it means going beyond the programmed control and producing behavior which is not expected or within the program. So therefore, I think the second issue is regarding the difference between the concept and of the autonomy. So, and third is outsourcing of decision making and difference between automated decision making and autonomous decision. And the fourth is personality and anthropomorphic characters. Maybe, as you know, in Japan there are many anthropomorphic characters. And one of the examples that when I saw the news that Hello Kitty is not a cat, I was surprised that the Hello Kitty is not a cat. Everyone recognizes that Hello Kitty must be a cat, but such anthropomorphic characters tends to use in the future. For now, we are heading for the metaverse society. So when we in our daily life, when we use metaverse, such anthropomorphic character will be more important from avatar of our daily life. And the fifth is, what is the difference between transparency and explainability? We are using the word transparency, but it must be difficult to transparent the output of the AI algorithm. So therefore, what is the difference between transparency and explainability? And sixth is the significance and the difficulty of the algorithm impact assessment. We should consider about such impact assessment from the point of the assessment of the algorithm. So we have an experience regarding the privacy impact assessment. Privacy impact assessments has been used in the area of data protection. However, algorithm assessment must be a very difficult but very important issue regarding the assessment. And last, the seventh is effort to establish AI principles. In 2014, I made a publish the 8 robot law principles, but when I insisted to establish the needs to establish robot law principles, no one cares. Nobody agreed to establish new robot law 8 principles. So, however, after I published 8 new robot law principles, about 2 years after I published these principles, everyone recognized that the need to establish new principles, and many companies and OECD, and so the last is the need to the effort to establish AI principles. So these issues that I should consider by reading Professor Chesterman's book.
Thanks so much, Professor Shimpo. Maybe just to pick up on the last one, I won't go through them all, but I'm very grateful that you clearly read the book so closely. On that last question, I mean, clearly you were ahead of your time, Professor Shimpo, back in 2014. As I point out, I think one of the deficiencies, and maybe this is a good thing to raise in a book club, probably all of you know this, is that for much of the history of artificial intelligence, the laws of robotics were those by Isaac Asimov. His famous 3 Laws of Robotics, first published in 1942 in the short story Runaround. And it is kind of an indictment that we didn't get much further than this idea of 3 Laws of Robotics. The period you point to, of course, where things started to take off, 2016, 2 things had changed by then. I think you were probably writing just as machine learning was taking off through the 2010s. And I think you're right that you were ahead of your time in terms of the need for regulatory principles. But also the consequences of AI, of technology. I think we're becoming clearer to more people around 2016 to 2018 in particular, because that coincides with the Cambridge Analytica scandal at Facebook, the election of Donald Trump, and the realization that this technology, this manipulation of data out in the cloud and so on, these amorphous metaphors, didn't just risk identity theft, didn't just risk fraud or someone not getting a credit application approved, it actually risked transforming an election, changing the history of the world. And I think that's what led the companies in particular to see the writing on the wall that they needed to address this regulatory deficit somehow. But thank you very much for your comments.
And Professor Shimpo, if any of the work that you did on the laws of robotics back then is available online, please do send. We'll post, and frankly, would love to sort of see how you were thinking of it at that early time. David, let me bring you in. So you are sort of our practitioner right now, given that you're most directly in industry. We certainly work with a lot of chief privacy officers and civil society and academia, but you're and you certainly still play roles advising government. But now that you're playing an industry role, helping shape policy, what resonated with you from the book?
Wow, where to begin? So first of all, let me say thank you very much for inviting me and giving the opportunity to read the book, which Simon, I don't think this was the intention, but it actually took me through a flurry of emotions, which was, and I'll explain. So having gone through the transition from regulator to practitioner and having the pleasure back in 2018, issuing the first guidance on the usage of AI. And I actually want to start with that because I remember one of the very senior person, when kind of read the one pager, the guidance, said to me, David, but this has nothing to do with AI and it's common sense. And that statement kind of, I don't know whether the word is matured or bubbled within me over the last few years. And I found it fascinating because when reading the book, other than obviously going through this wonderful history of law and putting a lot of context, because I'm not a law practitioner, I avoid the law in a positive sense as much as possible. But when I always talk about data, I talk about it being an onion. With every layer that you peel, you cry a little bit more. Dear sir, you have now made my onion multidimensional. But it really showed the degrees of complexities and the evolution that we go through. And I kind of made a note that I wanted to mention this, that I really hope in the future we will look back at today's necessity of wet ink and wet documents as today we look back at taking animals to court. And that really brought me to the point of, if you think about this discussion and discourse about AI, at first, from a practitioner's and implementation point of view, it is so many things. We are talking, and you covered in the book in terms of the aspects of the automation, the automative aspect of it. You're talking about the statistical nature of learning from historical data, dealing with the unknowns, and then finally, and deliberately or not, talking about the possibility of sentience, which a lot of times is kind of what is conjured when we say the word AI. And how do we deal with this legality when you're dealing with a new sentience, effectively? And is it sentience? The reference to the monkeys and so forth. So the things that kind of came to my mind and really thought from a practitioner's perspective is, do we understand, and are we over extrapolating the definition? How do we bring it back to the reality of today and the practicality of today of what is it that we're doing? And then secondly, it is the context in which we're applying to it. And I think that is something that really nicely came out. And if I may have the opportunity to ask, because that was one of the questions that kind of was relingling with me, given those two elements of the definitions of AI, what really it is and what is it we're experimenting, and is it ready today? Like I would argue, I think, that we don't yet have artificial sentience. To the automative aspect of it is, do we even need to regulate AI? And I'll explain what I mean by that statement, is because by saying, do we need to regulate AI, it kind of throws us to, as a practitioner, or as well as looking at it from a law perspective, is that we need to regulate AI in a very literal sense, which from a practitioner's point of view, literally equates as I need to regulate a mathematical equation. Or is it a semantical reversal of we need to regulate the application of AI? And once that's put into context, it really nicely sits in. And I think that's one of the things that really came out to me is we thought about these things. We may have not come up with the answers, but we have thought about these things. And ultimately, it's the application and the context that matters. AI may result in some turbulence and accelerate certain elements, but it's really that. So that's kind of a thing that really came out. And I wanted to ask to elaborate on that. And then just one final point, because Sara you mentioned, and I thought I love giving pop fiction commentary, is the point about the consistency with, say, the jurisdictional system. And one of the allures of using AI is having that consistency. But if I quote Asimov's foundation, Keio, and essentially the genetic dynasty, that is exactly what we do not want, because it eliminates the ability to evolve. But I just had to throw that in. But going back to that point about the definition, and is it really about the regulation of AI, however matter it may be, of a semantics?
No, it's much more than a question of semantics. And indeed, there's a very insightful, I think it's about 20 years ago, there was a symposium on computer law, or cyber law, I think they called it. And the dean of an American law school essentially presented a paper called The Law of the Horse, and basically said that computer law or cyber law made no more sense than having a law just about horses, because horses come up in all sorts of contexts: transportation, labor, meat, the potential damage to property, but you don't have a law that tries to encompass everything around a horse. You rather say, well, the law applies, and the horse is one part of the context. And I think that's a big part of the answer with AI, and that's why I hope the book is read as not saying you need one solution to one problem posed by AI. Rather, AI, of course, impacts all manner of technology, all manner of areas of society and economy and politics. And so the starting point is, how do our existing laws apply to this new sphere of activity? And as we've been saying up until now, a lot of it can be managed, but not all. And so there are some arguments that I make in the book for red lines. I think we should draw a red line at delegating life and death decisions to machines. I think we should restrict the ability of governments to outsource public sector decision making to machines. I think that should just be unlawful. As I was saying earlier, a government regulator shouldn't be able to outsource a decision to a private company any more than he or she should be able to outsource it to a machine. But there is that speculative element that you touched on, of the kind of robot consciousness sentience argument. And that was candidly a bit of a dilemma for me in the book. And I can tell, just between friends in this book club, I had an article rejected from a major law review because I touched on this question. They said, put that in the science fiction journals. And I think it remains science fiction. The computer scientists that I've spoken to, no one sees a serious path to sentience in the next 5-10 years. But there is a real debate. And I think it is moving from the pure speculative literature into more serious literature to think about, well, don't necessarily put it in the robot consciousness argument, but in the sphere of uncontrollable, uncontainable AI. I think that's not science fiction, that we could create an entity that would have abilities that we can't control. And so I do argue in the book that here we might want to draw, again, on a different kind of history, that of nuclear energy, where I think at the early stages of nuclear energy, which coincidentally was being developed at the same time that Asimov was writing his short story with the 3 laws of robotics, scientists like Nicola Fermi and others realized that this had enormous potential for good in terms of energy generation, medicine, agriculture, but obvious also potential for terrible harm. And so the question I think we will confront, not necessarily today, but 5-10 years from now, is how we can continue to get the benefits of AI, even as the prospect of an AI system, whether it's smarter or more conscious or whatever, at least is going to pose challenges to us in terms of containing and controlling it. We will, I think, get to the point quite soon that we need to start drawing limits on how we pursue those paths, because otherwise there is a risk of the kind of thing that Stephen Hawking, Elon Musk, Bill Gates and others have warned of, that there could be ultimately an existential threat. And that's a sphere of activity that there are serious research centers looking at, the possibility that AI could pose this existential threat. So I think it has moved from the science fiction to the world of regulators, although it's probably too early to start stopping research. I think that would be premature, but at least we need to go into research with our eyes open.
You know, one thought on why perhaps some of the regulation focuses on regulating the equation rather than the context and the output. You know, in some of the critiques of AI treating different people differently, different classes of people differently, and so forth. A lot of work is done, and we see that indeed, because of a certain data point or a certain calculation, wealthy or poor or people of one sort of background are treated differently. And we're left with unanswered societal questions as to whether or not that ought to be against the law. We obviously have areas where we've got societal consensus, but we have other areas where it's not quite clear. I'm having in mind one well-known example of a county that was using a machine learning algorithm to help make decisions as to whether child abuse workers should go out into the field and investigate complaints. And it turned out that one of the criteria that was being included was whether people were on public benefits, whether people were getting assistance, which unfortunately has a high correlation with child abuse. And clearly, when this was exposed that this was a factor, it was quite concerning, and it was really the basis of this big expose. But at the end of the day, what wasn't well answered was, okay, should you therefore now not use that information, understanding that you will miss some very valid complaints and have some kids abused or killed? Well, that's a hard question, right? So a lot easier to point at the algorithm than to say, you know what, there's some really hard questions that we don't have good answers to in society that are unfair, inequitable, and all of a sudden we're being forced to face them because we can point to the technology and see more transparently sometimes that these are factors that are being included. Clarisse, let me go to Paris. And I know you had lots to say and you've got comments. Please, floor is yours.
Well, I mean, lots to say like everyone else. I think I'm the only one, Simon, who can say today that, your book really keeps me awake at night. It's my 43. But I mean, the other discussants and people in the chat will probably be better placed than me to talk about AI. My first overarching comment was before looking at the book, I was actually looking at the author. And actually what maybe not everybody knows is that Simon writes many other things than law books. He also writes about legal education, the globalization of legal education, higher education. He writes about international human rights law, all sorts of things. He even writes young adult fiction novels, and not everybody knows that, including the Arcadia trilogy, which I read and personally enjoyed, even though I'm not that young anymore. And on top of that, you work in different areas of the law. Again, international public law, state reconstruction, post-conflict. I mean, really hard issues, and data protection and AI in the middle of all of that. And I was thinking, like, what's the common pattern? And I thought, the beautiful thing is that you basically, you strive to educate us, students, readers, to make the world, I guess, safer and more just and a bit more fair, hopefully, and to protect the dignity and the humanity that resides in each of us. And I find that beautiful. That's the role of an academic. It's a bit high level, but I think we should never forget the author behind the book. So thank you so much for doing that. And it's great that we can have a book club event on this. No better person to start our first book club in Asia Pacific than you, really. My question to you is around regulation, since I'm a former regulator, and that you can't do away with that. It sticks with you forever, I guess. David, probably same. I mean, the cruelty of publishing a book that weighs on regulation and technology, that 6 months after publication, already so much has happened. And then, bam, we have a draft EU AI Act, and China has come up with, China is too large, but a number of bodies in China have come up with different types of initiatives. And are there any, my question is very basic, but are there some things in the book, some comments, some parts that you would have amended that you might want to review now that we have these hard regulation coming up? Because we are in the age of hard regulation already, with extraterritorial effect like GDPR It's not fiction. It's already here. I'm not a big fan of the precautionary principle, by the way, but you know, we're there.
Yeah. So I think I think David might have been part of these conversations. I was a little bit optimistic about the move towards autonomous vehicles, like many others. I thought it would be coming sooner than now. It looks like it'll be further off. I've got a 17-year-old son, and a few years ago I optimistically hoped he would never have to drive, but clearly that's not going to happen. On regulation, I mean, the book was being finalized, and I added 2, I think, footnote references to the EU's draft AI regulation. But that will take some years to get towards implementation. But it goes back to what Professor Shimpo was saying with the kind of explosion of rules, frameworks, principles. And what's really interesting here, Clarisse, to your point, is the calculation being made around the world about not how to regulate, that's part of it, but when to regulate. And that's maybe a really interesting question to focus on, because in Singapore, and I think David and Clarisse will know this well, we had an explicit discussion, and David was at the heart of much of this, and concluded, no, we don't want hard regulation for fear of unnecessarily constraining innovation, and because there were too many unknown unknowns. And this links up with a scholar's work that I touch on in the book, David Collingridge, the Collingridge Dilemma, which is that in an early stage of innovation, early stage of development of new technology, it's easy to regulate because you can just shut things down, you can prevent things, you can impose costs, but you don't know what you're trying to prevent. You don't know what the potential harms are. And so if you wait, then the benefit is you get to see what the harms are, but the costs of regulation go way up. And we've seen that, for example, with data protection. Go back to 2004, you could have imposed all sorts of constraints on Facebook when it was still the Facebook. But come forward to 2022, that's much harder, and we've got sophisticated regulatory debates. In terms of updating the book to deal with some of these changes, I mean, I'll wait a little while. I do have a day job, but clearly this is a book that, I mean, the hope with a book like this is not that it's going to be cited, back to Jules's point, like the Bible and the Talmud, but you hope it will have a shelf life of some years. And that's really why I tried to be kind of cross-jurisdictional, tried to be technology agnostic, because what I was hoping to outline was ways of looking at problems, showing that we've been looking at them for decades, in some cases for centuries, and that moral framework, the kind of regulatory questions we should be asking ourselves, those will continue, I think, for the foreseeable future, even though the specific technology that I'm talking about and some of the rules that are being imposed will change. But yeah, maybe we'll come back 3-4 years and I might have to do a second edition, or maybe publish it, with, I'm not going to do a wiki version, but yeah, it might need some updating, certainly.
Gabriela Zanfer Fortuna points out that she really appreciated the way the chapters very often started with a case summarized, a real life event. I'll tell you one thing I appreciated was there were different things I learned from history. I mean, I didn't realize there were trials of animals, and it sounds like this was hundreds of years of history. We tried animals, and wow. And I certainly use the word freelance all the time, and had no clue that freelancers were free mercenaries with lances who indeed did battle. I mean, it just feels like it's amazing that this book was only 246 pages, because I felt like there was, it in the hands of somebody with maybe more wordy of a pen, there was so much packed in that you sort of just, brought in, easily, because of, I think, an incredible scope of, you mentioned many of your colleagues who helped sort of influence your thinking. What did anyone else learn, right? I mean, you're all, I felt in many areas, what you did was you really articulated, we've all been talking about the need for transparency and sort of human in the loop. And, we've had these conversations as legislators have worked on bills and so forth, but you kind of brought a framework and gave us a way to think about it. And then there were just areas where you brought in a whole area of, law that I didn't appreciate ought to be, reflected. What did anyone else sort of learn that you didn't, have at your fingertips that you're now going to, perhaps look to as you come back to the next, AI sort of regulatory conversation? Any real gems that you want to share?
Or things that you thought were terribly wrong?
Yes. Anybody want to disagree? That's quite fair as well. David, go ahead.
Oh, okay. I was going to say, Professor Fumio, but no, I was about to say, and again, now that I'm kind of in the role where I have to eat my own lunch in terms of implementing and executing AI, which is actually fascinating position to be with. What actually you've really done, and Jules, you've covered that really nicely. That it's really packed in terms of providing a lot of information with respect to the context, and I think I want to emphasize that point because, as a practitioner, as someone who does look at it as the math effectively, it is the understanding of the context and the understanding that a lot of these elements have been thought of. And again, I want to emphasize, may have not been concluded, but have been thought of. So therefore, which are the ones that may be a bit more sensitive? Which are the ones that may need to be framed differently? And which are the ones that actually, you know, something, we can just run ahead and we don't need to wait. I think that's the most important element for officiate regulation to come and say, you know, thou shalt not. We can start in an implementatory point of view, start putting in place these practices or surfacing these practices as a matter, and I've recently been calling it trust and safety nets. And what I mean by that is exactly as you emphasize in the book, in terms of, are we resulting in a situation of life and death? Well, then hold on a second. We don't want a situation where the machine does a decision, whether it's an automated, intelligent, or we can have the argument of sentience. So how do we make sure we put that control in place that flags it up by saying, hey, I can do this, but I really think you need to look at this and at least give me a thumbs up to those situations which are annoyance in bed. So I think the simplicity, if I may even say, and the elegance of that actually is very, very important, and something that actually I personally would thoroughly encourage all practitioners to not wait for some existential and borderline theological questions to be answered, but really taking what we have been addressing through history and implementing. And the ones which you don't, you know something, I'll be the first to say, it's not a question of can we, it's a question of should we.
Yeah, I mean, just to touch, so go ahead.
Professor Shimpo, did you have a comment that you were going to mention?
Please go ahead. Yeah, please.
Well, just very briefly to respond to David's point, I have a colleague in a bank, I probably shouldn't say which bank in Singapore, who explains this to his colleagues, saying, as you're developing new applications, you want to be helpful, but not creepy. And that kind of distillation brings it down to the moral sensibilities of many of his colleagues, because a lot of law is not rocket science. A lot of law is just human morality. And the reason why most of us comply with the law as individuals is not because we're worried the police are going to come and grab us and drag us off to prison. It's because the thought of breaking the law doesn't even enter our minds. Or if it does, it's quickly pushed out again. And so I do think, yes, you need guidance in some areas. You need sticks in some areas and occasionally carrots. But a lot of this comes down to, and I think there is an increasing awareness, as we were saying, over the last 8 or so years, it's become more apparent that a lot of this devolves down to the companies, the programmers, and different levels of regulation. The programmers engaging in self-restraint, the companies realizing that if they make a mistake, if the law doesn't punish you, the market will.
Professor Shimpo.
Yeah, from the point of the regulatory framework for the AI, so we have been considered regarding how to regulate the AI, and at the same time, and as Professor Chesterman indicated, when to regulate the AI. So, for example, the Japanese government started to not regulate the AI from around 2017 to consider about basic principles. However, the purpose of issuing the principles means that not to regulate AI. This means that without regulating AI, how to struggle with how to cooperate with, or how to coexist such an emerging technologies. So, however, I have been opposing the way of how not to regulate AI, because we have to and we should regulate AI. So recently, I'm very much impressed about the issuing of the new EU AI Act. So European Union trying to establish new Artificial Intelligence Act. So this rule sets out a horizontal rules for the development and the communication of the use of AI-driven products, services, and systems within the European Union. So I think from the point of the regulatory framework, the European approach will be the global standard to produce new regulation regarding from the point of the very sophisticated product safety framework based on the CE marking. So we have to consider the new regulatory framework, but at the same time, some government has been hesitating to regulate AI because such emerging technology needs to the innovation. So regulation means to to stop the new innovation. So therefore, I'm very much impressed about the new regulatory framework for European approach from the point of the safety management of the product and service. How do you think about such new approach of the European Union? Approach to
so clearly the European Union is hoping for a kind of Brussels effect like we had with data protection. I'm less optimistic than you are because I think the data is at least clearer in terms of a defined sphere of activity, the collection, use, disclosure of personal data, whereas AI is such an amorphous group of technologies. And there are clearly countries that completely disagree with things that the European Union doesn't want to do, like real-time biometric surveillance. I think it's kind of striking that one of the other trumpeted global efforts at regulation was UNESCO's set of principles, which, I mean, to pick the most obvious example, China signed on to a document that says there should be no use of AI for the purposes of social scoring, which is one of its current policies, or real-time biometric surveillance, which many countries engage in. So I think it's back to this question of what regulation of AI is. I mean, I think the European Union will draw certain red lines for the European Union, but I'm concerned that that won't spread across the rest of the world, partly because those lines are drawn, if you like, too broadly. What I suggest in the book, and this is really kind of speculative, is that we consider a model a bit like the International Atomic Energy Agency to try and draw those lines very narrowly on where there could conceivably global consensus. But even there, I mean, one of the lines I point to, which many but not all people would agree with, is on lethal autonomous weapons. But even there, we haven't seen global agreement on those narrow questions. So I think global regulation is going to be a real challenge. And although the European Union can regulate for the EU, I'm not convinced that that will spread around the rest of the world.
We're close to the top of the hour. I want to get two quick comments from Sara and Clarisse. Sara, can I ask you, you've been involved in the IEEE efforts and other sort of global regulatory efforts. Simon in the book proposes new agency models and learns from nuclear regulation and other areas. Really intriguing. Do you see a hope of global as opposed to GDPR for Europe, different models for different countries, efforts to somehow bridge with adequacies or safe harbors or the like? Is there a global standard, a global code? Simon points out, and others have pointed out, that many of these global codes are all quite similar in having the same sort of general high-level key points. So, and it's when the devil gets into the details that we find that it's the application where we don't have the guidance or agreement. What's your thought on whether there's a global standard that's going to be possible here?
I'm a little sanguine on the possibility of a truly global standard for something as encompassing as AI. I think it's establishing that standard for particular sector level AI, particularly the low level AI that we say use on our desktops on a regular basis to automate things like data entry, right? Starting there and building up may be a useful approach. Trying to start from let's define what AI ethics is, for example, and all come to agree on that and then define standards based upon that. There's a lot of effort there, and all of that effort should be applauded. But I wonder what the final traction is going to be. Perhaps we could look to something like the UK is trying to do to create some of its own internal standardization and internal standardization efforts that build from more of a global consensus into a national context. I think the impulse of international law is a good one here. The history of international law on things like law of the sea, it's long, it's complex, but it's not necessarily covered all things. We still deal with piracy today. And, Hugo Grotius wrote about it in the 1600s. So perhaps there's areas in which we could imagine some things being filled in over a much longer period of time than I think we are all willing to tolerate. So
can't resist putting up Grotius.
Yes, exactly.
Wow.
Funny. That's awesome.
Perfect.
Let me pitch that over back to you, Jules, or to Clarisse, because sitting in APAC.
I have two questions for Clarisse. Clarisse, given that it's 3 a.m. in Paris, will you go back to sleep or just have more coffee and stay up? And number two, do you have a final comment?
I'm going to read the book again, looking at it from an entirely new perspective. I think we're just over the hour, so could I make just a comment that's unrelated to the book? Last time I met with Fumio in Tokyo was in May 2018, and he'd actually invited me to attend a conference very quickly after a meeting at the PPC, which was on the law of robots. And it was all in Japanese. I didn't get anything for the 2 hours. But at the end of the talk, someone said, Fumio is really the grandmaster of robot law. So you must know that even if the principles didn't have a lot of impact in the moment, at least you are the grandmaster of robot law. So, I have tons of questions, Simon. When I'm back in Singapore, I will definitely run to your office. I would love to see how FPF Asia Pacific could actually build on these conversations and what we can do to, do more and activate these conversations further. But thanks so much. It's too late for more comments.
One sentence to follow up Sarah's very, very interesting point. International law is slow, it's deliberative. That's one of its strengths. But responding to technological innovation is not one of the things that international law could do well. And so I think you're absolutely right. We need to be looking at multiple levels. And just one case study that I think people should pay more attention to is Estonia, which is a highly digitalized society. And there was an interesting discussion whether they should have a law for AI. And this very sophisticated society ended up concluding, no, it doesn't make any sense. So we'll have sort of sectoral regulation, we'll draw different principles at different levels and try to regulate that way.
One example that you bring in, which I'll close on, is the example of how when you poll people to determine what would be ethical in a vehicle making a decision, they consider all sorts of factors like, is this an older person? Things that we know may not be actually ethical to consider. And at the end of the day, when you then say to them, well, would you like a vehicle that makes ethical decisions and perhaps puts you in a ditch rather than, causes harm to someone else, they actually don't want to buy a vehicle like that. So, wow, right? We're jumping to legislate when there are these incredibly complicated end decisions that we frankly don't know how to deal with. Anyway, we will be far capable of evaluating and grappling with these decisions because of this book. So if you listened and you haven't yet purchased it, this one is well worth your time. The next read will be Snow Crash. You need a bit of a novel, and it seems like it's a fiction, a nonfiction story at this very interesting time. So hopefully you'll read along. Please join the book club if you haven't by signing up at fpf.org so you can get emails about the next book in our queue. And Clarisse, thanks for being up so late. Sarah, Fumio, Simon, thank you all. Good morning.
Thanks,
good night.
Thank you, everyone.
Thanks to everybody who joined.
Bye-bye, everyone.